Good afternoon, everyone, and thank you for attending today's webcast on responding to kitchen sink complaints filed by franchisees. My name is Eric Yaffe, and over the next hour or so, Iris Rosario and I will discuss these kinds of complaints, including defenses that can be interposed to these kinds of complaints and strategic considerations for you to keep in mind. Iris and I have litigated and tried several of these cases over the years, and we hope we can help you in assessing and responding to these types of complaints, which we find are filed very frequently by franchisees. We're going to focus today on what is typically alleged in these kinds of complaints first, and secondly, what kinds of defenses are out there for you to consider when responding to these types of complaints, and finally, what are some of the strategic considerations that you can employ to assess and handle and manage these kinds of cases, which can sometimes be quite sprawling? Over the next hour, you will actually not be able to be heard, but if you do want to ask any questions of us, please use the chat function, and we'll try to leave a little bit of time at the end to answer some of your questions. So let's talk first about what we're even talking about when we think about kitchen sink complaints. These are generally complaints that are very lengthy in terms of the number of pages you'll see in the complaint. They contain a lot of factual allegations and a lot of claims. They're generally not terribly focused. Everything is sort of thrown in, which is why we call them kitchen sink complaints. And they involve a lot more work on the part of the litigants and even the court. The courts tend to dislike these kinds of complaints, and as you should have in front of you now, we've actually provided you with a statement by one of the courts in the Western District of Pennsylvania in the Hauser case, where the court stated, among other things, that this kind of genuine dispute becomes almost impossible to discern when it is buried in pages of various allegations, some of which may not rise to the level of a viable claim. What's really important in these kinds of cases, if you're the defendant, if you are the franchisor, is to try to get your arms wrapped around the case very early. Take control of the case. Make sure that the court is well aware that this is a case that perhaps doesn't have a lot of viability to it, and you're going to employ strategies to make sure the court understands that and will hopefully favor you in the end if you're the franchisor. It also, of course, can be very costly to both parties. So one of the things you're going to be wanting to do is to narrow the case as much as possible early on. But before we get to some of that and some of the strategic considerations, I'm going to turn it over to Iris for a moment to talk about the types of claims that you would typically see in these complaints, and then we can talk about how to respond to them.
Well, good afternoon, everybody, or good morning, depending on where you're at. As Eric mentioned, I'm going to talk about the general claims that franchisees typically allege in their complaints, and shortly thereafter, Eric will discuss some of the more franchise-specific claims that you'll see in these kitchen sink complaints. As Eric mentioned, kitchen sink complaints are often riddled with a number of claims and factual allegations, and oftentimes claims are thrown in to charge the franchisor with having an improper motive, and most of the time these complaints are written as such and are slanted as such, is that they're alleging some sort of violation, some sort of motive that the franchisor has against the franchisee that's resulted in some sort of adverse action. I'm going to discuss more of the typical general types of claims that you'll see in these complaints. And then Eric will follow with the more franchise-specific ones. The first one that franchisors should be aware of and carefully review is a general contract claim disguised as a tort claim. These are tort claims that arise under or are related to the party's contract, but the franchisee is alleging tort claims that emanate from that contract. And these include your fraud, misrepresentation, fraudulent inducement, and negligent misrepresentations. And as franchisors, more experienced franchisors has experienced is that these run the gamut from an alleged misrepresentation made at the start of the parties' relationship to any type of perceived fraud committed during the course of the parties' interaction. The primary reason why a tort claim is alleged, such as fraud or some other claim, is because many franchise agreements limit the type of damages franchisees are able to recoup. These include limitations on punitive damages, lost profits, and other types of damages. And with good reason, franchisors typically try to limit these forms of damages. To try to recoup damages beyond breach of contract, franchisees will try to allege a tort claim. Another reason for the tort claim is to get around any jury waiver provision. The waiver clause typically found in franchise agreement limits the ability of a franchisee to seek a jury trial. That's why jury waiver clauses should be written in a way that forecloses a jury trial even when a franchisee alleges a claim in tort. Turning now to tortious interference, which is another claim typically filed in these kitchen sink complaints. In that case, the franchisee will allege that the franchisor has interfered with the franchisee's relation with a third party. That is, there was an intentional conduct that induced a party to either breach its contract with the franchisee or not perform with the franchisee. Claims of tortious interference with contract or relation can arise in development cases where the franchisee has contracted with architects and developers for the construction of a site. The allegation in that instance is as follows. By the franchisor rejecting a site, the franchisor has interfered in some way between the relationship between the franchisee and his developer or architect. Claims for tortious interference with contract or relations can also arise in the context of a transfer, where a franchisee alleges that by rejecting the transfer, the franchisor has interfered with its relationship with the buyer. Beyond these two types of tort claims, you'll also see in complaints are equitable types of claims. The first one being unjust enrichment. An unjust enrichment is a quasi-contract claim and is intended to apply in the absence of a valid contract between the parties. Typically, a franchisee will claim that it conferred a benefit on the franchisor and that the franchisor has been unjustly enriched. Unjust enrichment claims are alleged in a number of situations, but they're mostly alleged in cases of termination, where a franchisor has proceeded or will proceed to terminate its franchisee. The argument in that instance is that the franchisee has paid advertising fees, royalties, or other fees, and has conferred some sort of goodwill to the franchisor at the location, and therefore the franchisor should not be unjustly enriched in terminating the franchisee or taking some other adverse action. You also see, related to unjust enrichment at times, you'll see a claim for promissory estoppel. As the claim implies, there has been a promise allegedly made by the franchisor, and the franchisee reasonably relied to its detriment. We've seen claims of promissory estoppel mostly arise in development cases, where the franchisor allegedly granted a location for a site and later withdrew its approval or rejected the site. They can also arise in situations where a franchisor allegedly promised that it would renew the franchise for another term.
Iris, let me just intercede for 1 second. One thing I would note is that all of these things that you've mentioned thus far in terms of claims, contract claims disguised as tort claims, tortious interference, unjust enrichment, promissory estoppel, all of these kinds of claims are often raised when the relationship simply goes south and when the franchisee has found that it just hasn't made the kind of money that it expected in the franchise relationship after perhaps a couple of years, a few years, and they start looking back and trying to get out of the arrangement by blaming the franchisor. And that's why you see these claims loaded up, contract claims disguised as tort claims, promissory estoppel, and the like. And I think all of these kinds of claims can be brought in that kind of situation. The promissory estoppel, for example, would be brought in the context of a franchisee arguing that you just simply made certain promises to me at the outset of the relationship that you didn't then fulfill. And so I think we see a lot of these kinds of kitchen sink complaints and all of these kinds of claims occur simply because the franchisee is unhappy with the general direction that the franchise relationship has gone in, and then brings a potential claim.
That's right. And you'll see the franchisee try to allege some sort of motive that the franchisor took. So some of these claims are premised and written on that slant that the franchisor is acting in some sort of improper way. The one other claim, Eric, that I like to mention is the implied covenant of good faith and fair dealing. And that claim is routinely alleged in complaints, such as kitchen sink complaints, and routinely alleged against franchisors. As most people know, every state implies in every contract a duty of good faith and fair dealing. That is, the parties to a contract are required to exercise good faith and honest judgment in carrying out their rights and obligations under the contract. Claims under the covenant arise in a number of factual scenarios, including in unlawful termination cases where the franchisee claims that the franchisor is targeting him, that is, has a motive, and wants the franchisee out of the system. These claims can also rise in the case of encroachment. So before we get to the defenses of these types of general claims, Eric is going to discuss more of the franchise-specific claims that you'll see in these types of complaints.
All right, so in addition to the general common law type claims that Iris has just discussed, good franchisee counsel will often bring franchise-specific claims and load them up in these complaints as well. What they'll do is they'll scrub the FDD, the franchise disclosure document, and the franchise agreement, and determine whether they can make a good faith claim against the franchisor based on the franchise documentation. So what you'll often see are the kinds of technical violations that probably many of the franchisor defense lawyers have seen in the past concerning violations of the 14-day cooling off period. That is that the franchisor has entered into a franchise agreement with the franchisee before the 14-day period of providing that franchise disclosure document has elapsed, or perhaps 14 days before the first payment is made to the franchisor is required as well, and that has not been met. There are other kinds of claims as well, especially misrepresentation claims that we see concerning, for example, the cost of building and developing the franchise unit. And there'll be arguments made that you said in your FDD or you told us orally that the construction cost would be, $300,000. It ended up being $700,000 or $800,000. The interesting thing is, of course, these claims oftentimes aren't brought right away when that occurs, but maybe a couple of years or a few years later, which of course raises the question of the sincerity of these kinds of claims sometimes when they are brought so much later. Of course, we also see that earnings claims are made or franchise performance representation claims, which arise oftentimes in a couple of contexts. One will be that the franchise disclosure document itself misrepresented the actual earnings that a franchisee would make over time. And the second type of allegation will be off the FDD, if you will, where someone within the organization has made some sort of promise about earnings or performance representations that ultimately weren't able to be met by the franchisee. Of course, mere puffery doesn't lead to a problem. That is, if someone says that you'd make big money out of this deal or that this is the opportunity of a lifetime, that sort of thing is not going to fly. But franchisee counsel will try to bring these kinds of more specific claims that something went awry during the early part of the relationship where these kinds of misrepresentations were made. One example of these kinds of misrepresentations that are thrown into the kitchen sink, so to speak, is a case called Pie 5 Pizza Company in the Northern District of Illinois in 2016. There, the franchisee filed a lawsuit that was based in part on alleged fraudulent representations made in Item 19 of the FDD, and this is often something that you'll see. The franchisee allege that the franchisor purposely didn't disclose the sales performance of its franchisees, but instead presented only the financial performance of its company-owned outlets. And of course, the company in this case was doing a lot better than the franchisees. So the franchisee argued that the franchise-owned outlets were not performing as well as the franchisor-owned outlets, and that they should have included that kind of information in the FDD. The court denied the franchisor's motion to dismiss, however, and the case is currently in active discovery. So you will certainly see these kinds of claims, these kinds of misrepresentation claims and franchise-specific claims. You'll also see violations of the state franchise statutes raised. As many of you probably know, many of the state relationship statutes have a good faith basis, a grounding that is necessary in order to terminate the franchisee, such as New Jersey and other states. Or, for example, again, New Jersey is a good example where there is a requirement that the franchise must be renewed unless you have a good faith basis for non-renewal. And so claims will be made that these statutes were violated as well. So you'll take some of these common law claims, you'll see some of these franchise-specific claims thrown into the case, typically in these kinds of complaints, which leads us to the question of, well, what do you do when you face these, 10, 20 claims and 40, 50-page complaints where everything has been thrown in? What kinds of defenses can you employ to deal with these kinds of claims? And I'm going to turn it over to Iris for a moment to address some of those issues.
So I'm going to discuss the general defenses that franchisors should consider when it comes to the tort claims and the other equitable claims that I discussed a few moments ago. And while time is limited to discuss all the defenses to kitchen sink complaint, I'm just going to touch upon more of the important ones. And going back to the contract claims disguised as tort claims, the fraud, the misrepresentation claims that are offshoot of the breach of contract claim, one defense franchisors should keep in mind and consider is whether the economic loss rule or doctrine applies. And that doctrine bars a party from recovering in tort economic losses suffered because of a breach of duty assumed only by contract. Courts in those instances will often assess the claim to see if the alleged fraud arises out of the context of the contract or whether it's a breach of an independent duty. If it arises from the contract, then courts take to the position that it's barred by the economic loss rule. So therefore, courts, what they do is they weigh whether the defense would apply and whether the claim that's being made, whether that tort claim is an independent duty that arises independently or whether it arises to the breach of the contract that is being alleged by the franchisee. If it's the latter, then it's foreclosed by the economic loss doctrine. And part of the premise of the economic loss rule is this notion that a party shouldn't be able to double dip when it comes to damages, that is, recruitment contract damages as well as tort-related damages that arise from the contract. And related to that, courts don't want to see breach of contract claims, tort claims being alleged that are truly arise under a breach of contract claim. So they don't want all these little tort claims that are being littered in the complaint. So that's one reason why some courts apply the economic loss doctrine. Some jurisdictions, Pennsylvania is a good example, applies what's called gist of the action doctrine. And under that concept, the gist of the action doctrine precludes a plaintiff from recasting a breach of contract claim into a tort claim. It's similar to the economic loss rule or doctrine in that the courts want to make sure that breach of contract claims are not recast as tort claims, and they want to ensure that breach of contract is breach of contract and tort is tort. Turning now to some of the defenses to the equitable claims, I put unjust enrichment and promissory estoppel on your slide together because the defense is pretty similar. As I mentioned before, a franchisee will claim that a franchisor has been unjustly enriched either through the goodwill generated at a location or the payment of royalties, and therefore the franchisor should not benefit. But unjust enrichment is a quasi-contract doctrine, and it only comes into play when there's no contract between the parties. In typical franchise suits, what you have is a franchisee alleging breach of contract and then also alleging unjust enrichment. And in those instances, courts take the position that equitable relief cannot be granted where the rights of the parties are governed by a valid contract. The premise is basically the franchisee can't have it both ways by claiming that the franchisor is in breach of the franchise agreement and also claim that there is unjust enrichment. Therefore, by simply pointing to the parties' agreement, the franchisor can foreclose a claim of unjust enrichment. Likewise, the defense to promissory estoppel is similar to the defense of unjust enrichment. Promissory estoppel is only available when there's no valid and enforceable contract between the parties. And again, by simply pointing to the franchise agreement, a franchisor can limit or foreclose this type of promissory estoppel claim.
So, Iris, if I can just note one thing. So, in talking about the economic loss doctrine as well as unjust enrichment and promissory estoppel, there's obviously a theme here, and that is that the franchisees in these kitchen sink complaints will oftentimes try to turn contract claims into something else. And they will take a simple contract case potentially and make it into a 4, 5, 6 count or more case because they're adding in a lot of claims that really are contract claims. But that means that the franchisor has to be attuned to this and make sure that it is, in fact, alleging and interposing as a defense that these truly are contract claims and that they are therefore precluded from bringing these other kinds of claims.
Right. And the franchisor in that instance really needs to go through the complaint really carefully and try to determine and at some point persuade the court that the claims being alleged by the franchisee are just really an offshoot of a simple breach of contract claim. Related to the implied covenant of good faith and fair dealing is the defense, again, that's similar to the unjust enrichment and promissory estoppel claim. And in that instance, a franchisor would generally point to the parties' franchise agreement, and again, foreclosing a claim under the implied covenant. And that is because, as expressed in the slide, the implied covenant cannot be used to add to or subtract from the express terms of a franchise agreement. So, for example, if a franchisee is alleging that the franchisor has encroached on its territory by putting in another franchisee, the court will typically look at the agreement. If the contract allows the franchisor to place other franchisees in the territory, then the implied covenant claim can't be brought. That is because the contract expressly speaks to that topic and allows the franchisor to take this action. And the implied covenant of good faith and fair dealing in many jurisdictions simply says you cannot override express contractual provisions. You can't, as the slide denotes, add or subtract to the terms of your franchise agreement. Turning to the claim of tortious interference, as I mentioned, it arises in the context of the franchisor deciding not to approve a transfer or rejecting a site. Many jurisdictions take the position that as to these types of actions, a claim of tortious interference cannot lie because the franchisor is technically a party to the contract. Because the franchisor is required to approve the buyer or a site, a franchisor cannot have tortiously interfered. So if the franchise agreement provides transfer provision, in which many do, that say that the franchisor has to approve a site or has to approve a transfer, then courts take the position that the franchisor is technically a party to that agreement and can take certain actions. Now, not all jurisdictions do recognize this view or this defense. And Pennsylvania, for example, doesn't appear to recognize the defense we just talked about. And in that case, the only way to sometimes attack a claim for tortious interference is to attack the element itself. Before I turn it over to Eric to discuss some of the franchise-specific claims, I'd like to mention a few other considerations that a franchisor should be aware of. First, statute of limitations or contractual limitations. Look for claims that on the face of the complaint are time barred. Many times a franchisee will put in dates or note when certain actions were taken. Those conceivably can be barred by inapplicable statute, such as statute that requires a franchisee to bring a breach of contract within a certain number of years or bring fraud within a certain number of years. It also can be barred by the contractual limitations period within the franchise agreement itself. And franchisors should make sure to review these items pretty carefully. And to the extent they don't have a contractual limitations period in their franchise agreement, they should consider adding one. To the agreement. In addition, look for standing issues. In preparing the complaint, franchisees will typically allege a number of alleged wrongs, not only against him or her, but also against a number of franchisees in the system. And franchisees, in order to have standing before the court, have to articulate some sort of harm that has occurred to them. And so, for example, a number of years ago, Eric and I had a case where the franchisee alleged discrimination. And the allegation of discrimination wasn't against the franchisee, but the claim was that by the franchisor rejecting these third-party buyers, the franchisor had discriminated against these buyers. And so it took on a motion for summary judgment later on in the case after much back discovery, the court ruled in the franchisor's favor and said, yes, the standing issue was a problem. The franchisee did not have standing to articulate the claim of discrimination, and the only party that could was the third-party buyer who wasn't a party to the case. So that's an example of just reviewing the complaint pretty carefully to ensure that the claims are valid and to weigh pretty carefully the defenses that are available to you. Now, Eric's going to talk about the franchise-specific claims, and these can be pretty similar variation of some of the defenses that I just spoke about.
All right, so Iris has just discussed a number of the common law type defenses that are available to franchisors in responding to these kinds of complaints. One other typical common law defense that I think is worth at least raising, and I know Iris and I have used this in the past, is the notion of waiver, and that is that the franchisee's actions and allegations are inconsistent with things that they have done in the past, and that they have in fact waived their right now to make these kinds of claims. And that's just another one that I think franchisors need to keep in mind. But there are also defenses to some of the franchise-specific claims that I'd like to talk about for a moment. First of all, statute of limitations is a very important defense oftentimes to these claims, claims that are specific to the franchise disclosure document or franchise agreement, and you really need to look at the franchise-specific laws in the jurisdiction that applies. In many states, there are statute of limitations that are specific to franchise-type claims. For example, in California, the California Franchise Investment Law and several other states have similar laws, provides for certain time limitations in which a claimant must bring a claim. And one of the things that's important in looking at these specific franchise statutes and statute of limitations is that they often don't have a discovery rule. That is, the trigger point for the statute of limitations will typically start when the violation occurs, and there's potentially a short statute of limitations in order to bring the claim, whether you were aware of the claim or not. And so you may be able to get rid of a lot of these claims when you ordinarily would not be able to under ordinary common law statutes of limitations. So, for example, again, and I'll use California as an example, it's California 31303, that section states that no action shall be maintained to enforce any liability created under the statute unless brought before the expiration of 4 years after the act or transaction constituting the violation, the expiration of 1 year after the discovery by the plaintiff of the fact constituting the violation, or 90 days after delivery to the franchisee of a written notice disclosing any violation, which notice shall be approved as to form by the commissioner, whichever shall first expire. So, in other words, at the outside, really, you're probably looking at 4 years limitations period, and with no discovery rule, it means 4 years from the time of the act or transaction, which sometimes is just receiving the FDD.
And just to add that, typically franchisees will allege that I didn't learn about the violation until my attorney told me so. And that is foreclosed under the California statute in the period of limitations you just explained.
That's correct. That's right. So I think the real takeaway here is that you just have to look very carefully at the franchise statute that might govern the particular complaint that has been brought by the franchisee, and make sure that you are invoking the correct statute of limitations, because that limitations period can often be quite short. It can be a year, sometimes even 90 days, and what we often see is that the franchisees are bringing these claims sometimes years after the statute of limitations has actually expired. So this can be a very important defense. In addition, some of these statutes will include a preemption type doctrine. So, for example, under the California Franchise Investment Law, if you're trying to bring a fraud claim that is, you might want to bring both as a common law claim, the franchisee brings it both as a common law fraud claim and a claim under the California Franchise Investment Law, you are probably going to be precluded from bringing the common law claim. If it's available under the franchise statutes, you'll probably have to bring it, or the franchisee will have to bring it under the franchise statute. And if they bring the common law claim on the basis of preemption, the franchisor can seek to dismiss that claim. And the reason why these laws exist, I think, in large part, is to prevent the franchisee from doing an end around on the statute of limitations period. So they will try to get the benefit of a longer statute of limitations on the fraud claim under the common law rules, which have a discovery rule, and potentially you could bring a claim many years later because you didn't realize, quote unquote, the fraud until years later. But you'll be precluded from doing that because of the preemption doctrine and because the fraud claim is covered by the franchise statute. California and several other states have these kinds of laws. So again, what's really important here is that you look carefully at the applicable franchise relationship law or franchise statute to make sure that you are covering these kinds of defenses when they are potentially available. More broadly, with respect to fraud claims, what we often do is focus on the notion of reasonable reliance, and which is an element of any fraud claim. And, the question oftentimes is whether the franchisee truly reasonably relied on the alleged representation or omission that they claim was made by the franchisor. And you need to oftentimes look closely again at the FDD, which might have disclaimers. They were well aware that there shouldn't be any representations or oral representations, and that those representations are precluded by the franchise agreement and the FDD. They were made well aware of a number of these issues and could not reasonably have relied on other statements or other documents that they claim form the basis for actions that they took. So again, with fraud claims, there are a lot of potential defenses that you can invoke. The question is, can you invoke them early in the game as a matter of law and bring a motion to dismiss, or do you have to wait until perhaps later in the case, summary judgment or trial, in order to prove your your point, and we'll get to that in a little bit.
Just to add to what Eric said, you also have to look at the particular franchise statute, because sometimes these claims, you're not required to prove up reasonable reliance, et cetera, under certain of the franchise statutes and some of the other provisions that are typically found in franchise agreement to kind of that go to the element of reasonable reliance also doesn't work in certain statutes. So you have to look carefully at the jurisdiction that you're in when making these types of defenses to these claims.
Another defense is to the rescission arguments that oftentimes franchisees are making. You know, the franchisees often, what they'll do is after, of course, again, years later, they'll say that the franchisor engaged in a number of different wrongful actions and engaged in malevolent conduct that caused them to lose their shirt in the franchise relationship. And they will seek to rescind. That is, they'll seek to get all of their money back that they put into and invested into the franchise. And there are a couple of critical things that you really need to look at when determining what defenses you have and how you should respond. One thing is that under most rescission laws in most jurisdictions, the action has to have been willful on the part of the franchisor. That is, it has to have been knowing and intentional conduct. And sometimes that's very difficult to show. But perhaps an even more compelling argument as a matter of law is that the law requires, in undoing a relationship, a contract, and getting your money back, a rescission action, generally that the party has to act quickly upon recognition of the grounds for rescission. So it's going to be difficult for someone a franchisee to come back after several years and try to rescind the contract, and you'll find a lot of case law on this point that indicates that a party really can't be aware of the facts underlying the reason for rescission and yet continue to perform under the contract for many years and get the benefits of that contract, and then only, you know, years later when they feel as though it's not working for them anymore, come back and try to rescind the contract. That's not going to fly in most jurisdictions, and that can be a very sound defense to bring. The last one that I'm going to talk about right now in terms of franchise-specific defenses relates to private right of action. We see over and over and over again in these kinds of kitchen sink complaints, franchisees bringing actions under the FTC franchise rule and sometimes state franchise statutes where there's no private right of action permitted. And it's pretty clear that the only entity perhaps that could bring an action for injunctive relief or for other kinds of relief would be the federal government or the state or some state or federal agency. And it's pretty well known that there's no private right of action under the FTC franchise rule. Nevertheless, franchisees still bring those kinds of claims. But you should be very wary of any claims that are brought under the franchise statutes in terms of at least looking to see whether there's truly a private right of action. If not, that's, of course, an excellent defense and can lead to a motion to dismiss or for summary judgment on any claim where that has been brought where no private right of action exists. So we've talked about the types of complaints that are brought and claims that are brought typically. We've discussed in some depth the defenses to these claims. And the question then arises, of course, well, aside from the technical defenses and the types of claims, what strategic considerations are there here? How should you really handle and manage and get your arms wrapped around these claims if you're the franchisor? What kinds of things should you consider doing more broadly and generally? And I'm going to turn it over to Iris to start the ball rolling on that issue.
So yeah, just you know, adding on to what Eric just mentioned, you've gotten a kitchen sink complaint. You're trying to figure out your claims, your common law claims, your franchise-specific claims. What are the defenses to those various claims? now you're, you're trying to figure out, do I get rid of these claims from the offset? Can I get rid of these claims? And I put in certain of the federal rules of civil procedure that a franchisor should kind of review and weigh in terms of assessing these kitchen sink complaints. And there are certain objectives that the franchisor should kind of keep in mind. First of all, if I file a particular motion, will I get rid of the entire case? And you have to consider whether on the face of the complaint a statute of limitations would apply, or whether the claim fails to state a claim on their face. So the first question you need to ask yourself is, can I get rid of the case? The second question is, if you can't get rid of the case, can it at least pare down some of the claims, leaving only those that are either able to resolve through a motion at some later stage or for some other strategic reason you want in the case. So typically you'll find in these kitchen sink complaints a number of claims being filed, including the technical violations of the franchise statute. And using, for example, that California statute of limitations, you can kind of rid of some of those technical claims and pare down to the complaint to really what it's about, what the dispute is about. So that's one second consideration a franchisor needs to keep in mind. The third consideration is, should I file a motion? And if you do, you're educating the court and your opponent on your position and what happened from your point of view. So you have to consider whether you want to do that at the start of the case or you want to leave that for a later stage. And related to that, if you do file a motion, you're kind of forcing your opponent to respond. And by doing so, you're requiring your opponent to take a position or flush out his or her claims. So, for example, will you get anything of value by filing the motion to clarify the claims or damages? Sometimes, and we found this to great effect, Eric, where we have filed a motion to dismiss and you had the opponent respond and clarify what the claims were or their damages. And those are statements that become part of the case and sometimes come back to haunt the franchisee in the later stages of the case.
And one other thing, Iris, in terms of paring down the number of claims and trying to make it a bit more manageable, is that there are, for many franchisors, there are going to be cost considerations and efficiency considerations. And if you can pare down the complaint from 10 claims to 3 or 4 or whatever the number might be, you're talking about less discovery, fewer depositions, and a more manageable case and a more cost-effective case potentially. And so that's a practical consideration that franchisors have to keep in mind as well.
Right, and assuming that you want to go through the cost of a motion, that's a good consideration to try to file the motion so you can pare down the case. You've evaluated the strategic considerations. Now you have to weigh what type of motion do you want to file. And you have to look at carefully at the rules of civil procedure, the federal rules of civil procedure if you're in federal court, or the state equivalent. And most of them are typically almost the same. I put in a number of the federal rules of civil procedure that a franchisor should consider as they're reviewing a kitchen sink complaint. For example, Rule 8 and the general rules of pleading. Has the franchisee violated this rule? That is factual vermin and claims are not short and concise. The second consideration is Rule 9. Are the fraud claims pled in such a way that they don't meet the requirements of the federal rule? For example, they're not pled with any specific, that is, they don't have the who, what, where, and when of a franchise claim. And the question a franchisor needs to consider is whether they want to file a claim forcing the franchisee to provide the particulars of a fraud claim or wait to a later stage during discovery, which Eric will touch upon here soon, to get more the essence of what the franchisee is alleging in terms of fraud. I put Rule 11 here, and that is more for counsel, and it requires before the filing a complaint for counsel to make sure that the complaint is reasonable and the claims, defenses, and other legal contentions are warranted by law. There are certain mechanisms and time limitations you have to comply with under Rule 11, but I put it in there as a consideration as well, whether a franchisor wants to file a Rule 11 motion before the court.
And one thing I'll say about Rule 11 motions is it can be brought at any time during the course of the case. We had a case recently which had involved one of these kitchen sink type claims where after some depositions had taken place, it became clear to us that there really wasn't a good faith basis to bring the claim against the franchisor, and we immediately filed a Rule 11 motion. At least we provided it to the other side, which is the first step, and they have a safe harbor provision in most Rule 11 state and federal Rule 11 statutes. And ultimately, the franchisee actually did dismiss the claim based on our Rule 11 motion before we even had to file the motion with the court. So it is something that can be effective in the right circumstance.
The next type of motion that a franchisor needs to consider is Rule 12 motion. It's either a rule motion to dismiss or a motion for judgment on the pleadings. And the standard for both types of those motions are pretty much the same. It's just a matter of timing as to when you file the motion. But really what you're saying to the court is that putting aside the factual contention in the kitchen sink complaint, the claims fail as a matter of law, and here's why they fail. And oftentimes, Rule 12 motion to dismiss or judgment on the pleadings is well worth it if it's clear from the face of the complaint, for example, that the economic loss doctrine applies, or that there is some sort of technical problem that's with the franchise-specific claim that's foreclosed by a statute of limitations. So, again, you need to consider whether you want to file a Rule 12 motion, and oftentimes there have been situations where, for some reason, the franchisor has waited and filed instead of motion for judgment on the pleadings. And finally, another type of motion, which I'll touch upon briefly, but I'll let Eric kind of explain this a little bit more, because it comes towards the tail end of the case after the parties have conducted discovery, is the Rule 56 motion. And by that, it's a motion for summary judgment, and you're pretty much telling the court that the facts are not in dispute and that you're entitled to prevail as a matter of law. And you've had the benefit of discovery, and you're pretty much telling the court, here's why I'm entitled to judgment, or here's why I'm not liable for the claims put in this complaint. And Eric, I'll let you touch upon discovery and the considerations a franchisor needs to consider as they're conducting discovery.
So discovery in dealing with these kitchen sink complaints can be quite extensive, and you need to address potentially a number of issues. If you cannot prevail on summary on a motion to dismiss, or if you cannot sufficiently pare down the claims, you're left with potentially quite a bit. And what you want to do is you really want to, in discovery, force the franchisee to defend their claims very specifically, because your view likely is that these claims either don't have merit or may be overblown, and you really want them to, during the course of discovery, try to defend those claims quite specifically. You want to box them in. You want to make sure that as you go forward, you're able to truly, at this point, pare down factually what allegedly had occurred and make sure that you're being very specific in terms of getting information from the franchisees. So you want to have very detailed interrogatories, what we call contention interrogatories, asking specifically what the basis is for each and every one of these claims, the specific basis. And you can use those potentially in depositions with the franchisee at a later point. Most likely, in these kinds of claims especially, you want to videotape your depositions, because you're going to be taking depositions of the key witnesses, and you are going to want to really force them to establish very specifically what their claims are. And oftentimes what we find is a lot of these claims fall very flat, and the the franchisee doesn't come across very well in the deposition, and you're much better off having that on video with a witness appearing live that you can show to a judge or a jury later on than you are looking at the cold, hard record in print from a deposition. What we've seen in discovery that we can oftentimes establish is that the franchisee's claims of being unhappy and not generating sales and profits over the years can often be belied by the evidence and by prior emails that they've sent establishing that they're satisfied and that they've been making money, and that you really want to get a hold generally of their finances. You want to get a hold of all the emails that might belie their claims. And similarly, you want to show that to the extent there's a problem, the problem we found oftentimes is the franchisee's problem with their own operations, with the way they've been managing the franchise and the way they have been dealing with the standards that the franchisor has set. And they've oftentimes fallen quite flat. And you want to show that because you're going to want to present that to the judge or jury to show that the reason why potentially they're not doing well doesn't have a lot to do with the franchisor, but it's because of the franchisee's own problems and issues. It's very hard for them to overcome that at the end of the day if you're able to establish that. So you want to, in the discovery process, bring out those kinds of facts. In addition, where it's available, you want to show, again, that they haven't really relied on these things they're saying the franchisor represented or did not represent or omitted from documents, and that, in fact, the facts are quite different. And you want to get all of that out during the discovery process. At the end, what you're really trying to do is to set everything up for, first, a motion for summary judgment. What you're going to aim for is to try to establish that the facts, at the end of the day, are really not in dispute. And you want to marry those facts to the applicable legal standards to establish that there's really no reason for this case to go to trial. You want to get rid of it on summary judgment because the facts are not in dispute and you are entitled to judgment as a matter of law. The problem, of course, with these kitchen sink complaints is that if you can't get past summary judgment, and if you cannot prevail on summary judgment, then you end up in a trial with a lot of, potentially messy facts and all kinds of allegations. And while a judge certainly is usually able to sort through that, whether it's a judge or a jury, you really don't want it to ever get to that case where there is always going to be risk and exposure to the franchisor. So you really are trying to gear yourself towards summary judgment and build that case through the discovery process. So in any event, we've gone through some of these. We've gone through some of the strategic considerations, and I will turn it over to Iris.
So before I, pretty much conclude the presentation, I also want to add on to what Eric was talking about, the documents and everything else that you're pretty much seeking through the course of discovery. And you want these documents to tell the story from your point of view, to flush out exactly your story to the judge and jury of why you're not liable. And the documents are the documents that you need or should get from discovery is a nice way of telling that story later on at the late stages of the case, should the case go to a trial or a jury. As we mentioned before at the beginning, we're going to leave some questions for people to ask. Before we conclude, though, I just wanted to remind everyone that getting a kitchen sink complaint is not a good feeling, and but you have to remember that these types of complaints are more of a disservice to the franchisee than to the franchisor. You have to carefully review the complaint and figure out whether the tort claims emanate from the breach of contract claims, or their statute of limitations or other defenses that you want to consider. You also want to weigh carefully whether you want to file a motion to dismiss in federal court, to dismiss the case or some of the claims, what you want to do in discovery and what kind of discovery you want, what documents you want. Finally, you just need to position, if the case is going to trial, you need to position your case for success before a judge if it's a bench trial or a jury if it's a jury trial. Thank you so much for listening. We appreciate your time. The webcast was recorded and it will be available to you later on in case you missed any part of it. In addition, our slides are available to you. And if you have any questions after this presentation, feel free to give us a call. Our contact information is at the beginning of the slide presentation. Eric's contact and my contact information are there in the event you have any further questions. Thank you so much.
Thank you. Bye-bye.